Good morning, and thank you for joining our session today. This is the fifth and final instalment of our Employment Law Update webinar series, which we hope you've enjoyed and found useful this week. We've hopefully saved the very best for last for you today, with a look at some important social media employment tribunal cases and how you can avoid some of the pitfalls associated with dealing with such cases. My name is Andrew Dunning, and I've been with Watershed for almost 6 months now, meaning so I can probably get away with playing the newbie card for just a little bit longer. I'll be joined today by my extremely talented colleague, Lindsay Murray, who somehow manages to combine being a mother to 4 young children with being a brilliant employment lawyer. I know it can be a struggle getting yourself dressed properly at times during lockdown, let alone 4 children, so kudos to Lindsay. As ever, we are also joined by Thomas Bennett, who's on hand to make sure that our technology is working and hopefully won't have to prompt us to unmute our microphones at any point. Our presentation will last for around half an hour today, and we'll aim to finish on time as we appreciate that it is a Friday and you're all busy people. If you do have any questions during today's session, then please submit them in the Q&A bar with your contact details, and we will follow up on them afterwards by email. We will also share the slides and a recording of today's session so that you can refer back to them or share them with your teams as you see fit. Okay, so on with the presentation. Over the last 20 years or so since its inception, social media has moved from being on the periphery of our communications to becoming a dominant feature of all of our daily lives. And although the channels may have changed over the years from the likes of MSN Messenger, MySpace and Bebo to Instagram, TikTok and WhatsApp, the trend for increased time spent using social media continues. This trend has accelerated further during the pandemic, with global digital consumption hitting almost 7 hours per day. Unsurprisingly then, social media has also had a huge impact within the workplace, as I'm sure you will have all experienced in some form or another. A 2019 Corona survey found that, on average, UK employees spent 13 hours per week on social media during work time, and that was before the pandemic. So we've selected 6 particularly juicy employment law cases involving social media and inappropriate use of emails to highlight some of the many challenges that may arise. And we'll also give you some tips for dealing with these tricky questions along the way. Turning then to our first case, which is, can I discipline an employee for working elsewhere when they are absent due to long-term sickness? So the facts of this case were that Ms. Gill was employed as a customer service representative for SAS Ground Services. She had been absent from work for a number of months due to sickness and was awaiting an operation, and she was still receiving full company sick pay. During this period, a colleague spotted that she had posted a video on Facebook which showed her attending London Fashion Week and reported this to management. The employer decided to carry out a disciplinary investigation and met with Ms. Gill to interview her as part of the investigation process. Ms. Gill explained that her visit to the fashion show had been solely for social purposes. However, in the Facebook post, Ms. Gill referred to the fact that she had been auditioning 300 models and choreographing a fashion show. A YouTube video was also discovered which showed Ms. Gill presenting a bouquet of flowers to a fashion show designer. So do you think that the employer is entitled to take disciplinary action based on these facts? We've come across several similar cases such as this, where the employee appears to be having their cake and eating it by engaging in other employment while taking full company sick pay. And it's not surprising that colleagues become irritated and report this to their employer when it is being flaunted on social media. If we turn to the next slide, we can reveal that the employer did decide to dismiss Ms. Gill for gross misconduct on the basis that she'd been conducting other work while signed off sick and in receipt of full sick pay. It also transpired during the disciplinary hearing that Ms. Gill had been filming in India during a previous unauthorised absence. We mentioned teammates feeling aggrieved, and the employer took into account the demoralising effect that Ms. Gill's actions had on her colleagues. Ms. Gill brought a claim for unfair dismissal, but the Employment Tribunal held that she had been fairly dismissed. The tribunal gave Ms. Gill's claim fairly short shrift and held that dismissal was a reasonable outcome in the circumstances and that a fair procedure had been followed. The case confirms that social media evidence in the form of Facebook post and the YouTube video in this instance can be sufficient for an employer to use as the basis for taking disciplinary action, up to and including dismissal. However, it is important to consider each case on its merits, and ensure that there is sufficient evidence to justify any action that is taken, rather than relying on hearsay. Make sure that any evidence is recorded as soon as possible, for example, taking screenshots prior to any incriminating posts being deleted. And always ensure that a fair and reasonable investigation process is followed, including allowing the employee the opportunity to comment. There is an important distinction between cases such as this one, where the individual was clearly playing the system by working elsewhere while receiving company sick pay, and other similar cases where an employee may be signed off sick, but their social media activity indicates that their condition is perhaps not quite as serious as they're making out. You need to be careful if someone is signed off with stress and anxiety and, for example, Bryant from Accounts complains that they've seen them posting pictures out walking in the woods on Instagram, as that would be something that's perfectly reasonable and probably beneficial for an individual to be doing while they are off with stress and anxiety. However, if Brian reported that he'd seen an individual posting a video of themselves skydiving when they're off with vertigo, that is likely to warrant further investigation. Moving on to our second case, this considers whether you can dismiss an employee for posting videos of horseplay in company uniform on YouTube. So this was a Scottish Employment Tribunal case, and the employee worked for Summerfield. He posted a 20-second video on YouTube of another employee in uniform being bashed over the head with a plastic bag full of plastic bags in a storeroom. One participant in the video, the individual being bashed over the head, was wearing the Summerfield uniform, although the Summerfield logo couldn't be seen and it was only recognisable by its colour pattern. Mr. Taylor did not record the footage and was not present or involved in the horseplay itself, and the footage had been recorded by another colleague around a year earlier. However, Mr. Taylor uploaded the video to YouTube after watching it while having some drinks at his house with colleagues. The video didn't exactly go viral, receiving a grand total of 8 hits, including those from management when they'd been prompted to investigate it, and Mr. Taylor took it down unprompted after 3 days. A couple of weeks before the incident, a Sunday newspaper had run an article about Summerfield due to a number of other online videos showing employees misbehaving, and the employer had sent a memo to store managers emphasising the importance of preventing such videos. However, the employee's store manager did not send this memo, and so the employee had not been made aware of this. So do you think that would be fair to dismiss Mr. Taylor in these circumstances? It's an interesting case, and there are arguments on both sides in terms of whether the conduct was acceptable or not, the seriousness of the conduct, and the potential consequences for Summerfield's reputation. If we turn to the next slide, we can see that the company did decide to summarily dismiss Mr. Taylor for gross misconduct for posting inappropriate film footage which brought the company into disrepute. Mr. Taylor brought an unfair dismissal claim which succeeded, as the Employment Tribunal held that the dismissal was unfair and that the decision to dismiss fell outside the range of reasonable responses available to a reasonable employer, which is the well-known test originating from the case of Iceland Frozen Foods and Jones. There was no evidence from which the employer could have formed any belief that the video had damaged its reputation. The dismissing manager had not even watched the video, did not find out how many hits it had received, and the employee's name or logo had not been visible. Excuse me. The dismissing manager believed that the incident had taken place within a Summerfield shop and that it featured an employee being assaulted, neither of which were true. The Employment Tribunal judge felt that the decision to dismiss had been wrongly influenced by the previous negative publicity regarding video incidents in the Sunday paper. The employer had also failed to consider alternatives to dismissal or taken into account any mitigating factors such as the employee's admission, his apology, and his 6-year unblemished record. The judge also made a comment that while an individual being bashed over the head with a bag full of plastic bags was not quite on par with classic Monty Python, it was clearly intended to be humorous rather than an assault. However, the tribunal did decide to reduce the basic and compensatory awards that the employer was awarded by 30% for contributory fault, commenting that the employee was blameworthy to a moderate degree. So this case highlights the importance of the decision-making process at the disciplinary hearing, which was deeply flawed in this instance. We would advise that all relevant evidence is seen directly by the disciplinary manager, and that any mitigating factors and alternatives to dismissal are considered before reaching an outcome. By taking these steps and ensuring that they are documented as appropriate in the outcome letter, for example, you're far less likely to fall outside of the range of reasonable responses, as the employer did in this case. If we turn to our third case, this involves a similar element of potential damage to reputation, and considers whether you can dismiss an employee for sending pornographic emails 5 years ago. So the employer in this case was Leeds United Football Club. I do always like to shoehorn a football-based case wherever possible. Mr. Williams was employed in a senior role at Leeds United as a technical director, earning approximately £200,000 per year. He forwarded an email via his work email address to a junior female colleague and to 2 friends who happened to be former footballers, Dennis Wise and Gus Poyet, who were both working for other clubs at the time of the email. The email contained a spoof PowerPoint presentation that included a series of obscene pornographic images and a message which said, "Looks like Dirty Leeds." For any non-football fans watching, Dirty Leeds is a nickname for Leeds United that dates back to the 1960s when they earned a reputation, let's say, for bending the rules through fairly hard and aggressive play. Management of the football club did not discover the email until over 5 years after it had been forwarded by Mr. Williams, when it undertook a fishing expedition to find a way to avoid paying Mr. Williams his notice pay after giving him notice of redundancy. The club had a policy forbidding use of the email system to send, among other things, obscene images, although Mr. Williams had never been given a copy of the policy. So do you think it would be reasonable to dismiss Mr. Williams in these circumstances on the basis of an email that he had forwarded 5 years ago and which the club had deliberately gone looking for? Or was it wrong for him to have sent an explicit email to a junior female employee and potentially risk the club's reputation by forwarding it to high-profile former players at other clubs, which could have been extremely damaging had it leaked to the press? Let's have a look at the next slide to find out. So Leeds United did decide to dismiss Mr. Williams for gross misconduct. Mr. Williams unsuccessfully appealed against the decision and instigated proceedings against the club, claiming damages for wrongful dismissal. The High Court held that the summary dismissal was lawful. Mr. Williams' actions in forwarding the email amounted to a breach of the implied term of mutual trust and confidence, entitling the club to summarily dismiss him. The fact that he had seen the policy was irrelevant, as it was clear to a person in Mr. Williams' role that the conduct was unacceptable. Mr. Williams had risked causing offence to the junior female employee and had left the club vulnerable to a harassment claim. His conduct had also risked affecting the club's reputation, which would have been very seriously damaged in terms of potential loss of sponsorship and trust with the fan base and the local community. This case gave some helpful guidance on the facts to be considered when assessing the seriousness of any breach. So the court held that it is necessary to consider all of the relevant circumstances, including the nature, degree, and consequence of the breach, and also the nature of the business and the employee's position. So in this instance, compared to the previous case, the employee's seniority was an important factor, along with the fact that Leeds United was included in his email address, and so it would be clearly possible for the email to be traced back to him and to the football club. This case demonstrates that unacceptable use of emails, the internet, and social media can be addressed even where it may be discovered long after the event. I've supported on a case in the past where a disciplinary investigation was being conducted into a completely unrelated matter, but during the course of that investigation, instant messages were discovered that had been sent between 2 employees dating back over several months, which contained extremely racist, offensive, racist, and sexist material. That case resulted in the employees exiting the business following a disciplinary investigation. In relation to the Williams case, while the fact that Mr. Williams had not seen the club's policy did not prove to be decisive in this particular case, we would always recommend that your policies are shared and promoted with your employees, which Lindsay will come on to talk to in more detail. So I'll now hand you over to Lindsay, who will talk you through 3 more equally juicy cases. And just a quick warning before I do so, if you are sensitive to explicit language or happen to have any children present, you may wish to avert their eyes now. Of course, that's no reflection on Lindsay, but it is about the content of her first case, as you're about to see. So with that, over to you, Lindsay.
Thanks, Andrew. So yes, I thought I would take a slightly different and potentially risky approach by putting the offending Facebook post on the screen for you to make your own mind up then about whether you think dismissal might have been fair or unfair in these circumstances. The claimant in this case was a Muslim who worked in security at London Heathrow Airport, and he'd worked there for about 4 years before he allegedly posted this comment on Facebook. The comment appears to relate to a news story about child abuse, but that was never actually put in that context in the employment tribunal. The Facebook page itself didn't have any privacy settings, and so this post was accessible to the public, and this employee's full name and his photograph had been used to set up the Facebook account. His manager only found out about this post by overhearing colleagues talking about it. And when he was asked about it, Mr. Anwar denied having made the post and said that his account must have been either hacked or cloned. He told his manager that he'd reported the comment to Facebook and that he was going to also report it to the police. He was dismissed and he brought claims in the employment tribunal for both religion and race discrimination, as well as unfair dismissal. And the tribunal dismissed his claims for race and religion discrimination, saying that they were satisfied that neither of these things had any bearing on the decision to terminate his employment. But they did say that his dismissal was unfair. And that was because, whilst the comments were definitely offensive enough to dismiss potentially fairly, the airport had failed to investigate that possibility that his account had actually been hacked by another employee. So moving on then to what this case tells us, you can dismiss for comments made on Facebook that could cause offence for being discriminatory, but it's really important that you follow the correct procedure before you do. So in this case, on appeal, Mr. Anwar had shown his employer some text messages that he'd exchanged with another colleague. And these texts suggested that it was an employee who'd initially given an anonymous witness statement about the post during the original investigation that had hacked the Facebook account. And the appeal manager interviewed the colleague who'd sent the text messages, but when she denied knowing who'd hacked the account, he didn't put those text messages in front of her and ask her why she'd said something different to Mr. Anwar. And it was that failure then that led to the finding of unfair dismissal. So what that reminds us of is that whilst you don't have to pursue every line of inquiry in an investigation, it is vital to have done as much investigation in a disciplinary as is reasonable in the circumstances. It's also really important to correctly identify the degree of risk to the company from the discriminatory comment. So ask yourself, how likely is it that that post will be seen? If the employee's got no privacy settings applied and has got photos of them wearing company uniform on the Facebook page, as Andrew talked about, then the risk of harm is obviously greater than if the posts are restricted solely to friends. But even then, if the employee has got work colleagues as friends, then regardless of whether there's any association with the employer on the Facebook page, that colleague will know where the employee works. And so there's the potential for the company to be liable for those discriminatory posts. So what about the next case? Do you think it was fair or unfair in these circumstances for this assistant head teacher to be dismissed? Well, he hadn't taken the explicit photograph himself. He hadn't posed for that photograph. And he had every reason to believe that the photograph had been deleted from that camera. It was a former student that was arrested and cautioned by the police for having unlawfully retrieved that photograph from the camera when it went into the repair shop. And following an investigation at the school, this assistant head was dismissed for gross misconduct for failing to do enough to keep that photograph out of the public domain. So what the school were basically saying was that he should have destroyed either the SIM card or the phone to make sure that that picture never saw the light of day. And the tribunal said that the dismissal was unfair. They said he had been the victim of a crime and there were no reasonable grounds for the school to believe that he had done anything wrong or had failed to do anything the school said that he should have done. They said the investigation had been inadequate in that the school had failed to actually put to the employee specifically what he was alleged to have done or not done. So this case highlights the importance of correctly forming the allegations in a disciplinary. The tribunal found that what was really being contemplated in this case was a dismissal for reputational damage to the school, but that was never put to the assistant head teacher during the disciplinary. It simply wasn't fair to have dismissed him for not taking enough care to make sure that his wife had successfully destroyed that photograph. But the tribunal did say that the existence of that photograph made his continued employment at that school completely untenable. And that was because the picture had circulated widely on Facebook and all the students had commented on it. And so for that reason, they found that he could have been dismissed for some other substantial reason, and they limited his compensation just to his notice period. So what action can you take then against an employee who's posted inappropriate photographs on social media? Well, the first thing you want to do is to make sure that those photographs are removed. So you want to report those posts to Facebook or Instagram, ask them to take them down. Ask the employee to take down the photograph too. And if they don't, then you'll be able to add failing to follow a management instruction to any potential disciplinary allegations if the connection with work is strong enough and that it's right that that photograph is removed for having an association with your company. Disciplinary action can, of course, be taken in the event that there's a risk to the reputation of the business or a risk of liability of claims from colleagues for discrimination. But you need to make sure that it's absolutely clear what the allegations are that the employee faces. That's what those cases are telling us. So moving on then to the last case that we're going to look at. I'm hoping that some of you will remember in 2018 when there was a reporter who went undercover as a waitress at the President's Club charity dinner. This was an all-male fundraising event, and it was attended by lots of male celebrities and politicians. And the reporter uncovered groping and sexual harassment at the dinner, but that the waitresses had been asked to sign non-disclosure agreements to prevent details of that conduct ever being made public. And the author of the tweet, which is on this slide, saw a Newsnight programme about the President's Club and tweeted this comment, confirming that news report as consistent with what her experiences had been when she was a hostess at the club. The Times newspaper picked up on her tweet and they asked her to interview anonymously for an article in their newspaper. And she asked her boss if she could speak to the paper. And whilst he said, "I wouldn't if I were you," he didn't actually tell her not to do it. So she gave the interview, and then when he told her off for it, she resigned her employment and claimed constructive dismissal. So was she unfairly dismissed? Well, this employee was the public affairs manager for the Big Lottery Fund, and she'd made it known in her Twitter biography that that was what her job was. And the Big Lottery Fund was a non-departmental public body that was required to be completely apolitical. It had a code of ethics that it shared with all its employees that expressly stated that whilst employees could engage in political activity outside of work, the lottery fund must not be publicly associated with any of those activities. And they had to take care that they weren't identified as employees whenever they were taking part in a political activity. They also had a social media policy, and that policy said that employees with social networking accounts who included the Big Lottery Fund in their profile had to include a disclaimer that said that their views were not those of the Big Lottery Fund, and she had actually included that disclaimer in her Twitter account. And the tribunal found that her boss, who was the head of public affairs for the big lottery fund, was widely considered to be an absolute nightmare to work for anyway. So the reprimand that she received was not because she was a woman who'd been subject to harassment. So there was no sex discrimination element here. But they did award her £6,000 in compensation for injury to feelings. And that was because they said her manager's treatment of her did follow a tweet about harassment in breach of the Equality Act. And so she had been subject to victimisation. And if you've been listening to our webinars all week, then that should test your memory a bit, as Mark spoke about victimisation in the session on Monday. And so if you haven't already heard it or you've forgotten, then you can go back via the links on our website and listen all over again. So what steps should you take in relation to a social media policy? If we move on to work our way through the list of things that we should be looking at. So firstly, you need to make sure that your policy is clear, that inappropriate comments that could be deemed offensive by a colleague or risk harm to the reputation of the business mustn't be posted on social media. There is a template social media policy on our resource website for those clients that subscribe to our annual support service. But if you don't have a subscription, then please do get in touch with us. You should also remind employees in that policy and in regular training. And there was a case yesterday that came out about making sure that that training is kept up to date. There was some training that had found to have become stale, and an employer wasn't able to rely on that to be able to successfully defend a claim. But it's really important that you remind employees that they can be named personally in claims for harassment in relation to comments on social media. Believe it or not, part of the sanction for breaching the rules on social media when I was working in-house was to have a one-to-one training session with legal, with me. And it often ended with an employee in tears because they hadn't previously understood the extent of the thousands of pounds of personal liability that they'd exposed them to when they'd posted racist or sexist comments on social media. The only hope that you have as a company of defending claims by offended employees is to be able to show that you took all reasonably practical steps to avoid the harassment. So you need to make sure that it's clear in your disciplinary policy that breach of the social media policy will be gross misconduct if it's serious enough. And also, I thought it was worth a reminder just to review your data privacy policy. So in a recent survey, 40% of employers confessed to checking social media before recruiting somebody. And I have to confess to having done that myself. And so you should update your privacy policy to tell employees and candidates for recruitment if you're going to use social media to make decisions about their employment. So also, specifically in your social media policy, be clear about the use of social media at work. So make clear if it's only break times in which any personal use of the internet can be made. And also tell employees if their social media accounts could be monitored during sickness absence. Because if nothing else, it acts as a useful deterrent. And as Andrew talked about, it should prevent them putting pictures of their hike up Snowdon when they've got depression and everyone else in the office is working twice the hours to cover their work. It should deter them from doing that. In fact, I once dealt with a claim by an employee who was off work with backache, who was sacked after he'd appeared on the front page of the local newspaper, who was celebrating him for having carried someone on a stretcher down a mountain after he'd rescued them as a volunteer with the Mountain Rescue Service. Completely inconsistent with the reason why he was off work. So there's just one other thing that I've thought of before I finish that isn't actually on this slide, and it's making clear that LinkedIn contacts that employees have remain the property of the employer, so that when their employment ends, it's clear that they have to return any information about customers to you that is stored on LinkedIn. So that's all from me this morning. Thank you so much for being with us for the webinar today and for all of your time this week for any of the sessions that you've joined. A link to the recording and all the slides for this webinar will be published on our website shortly for you to share with colleagues if you think they might be interested. This is the last of the webinars in the series, but we will be back later in the year with more. And whilst we hope you've enjoyed the topics that we've covered, if you've got ideas for future sessions, then please do share them with us. And please do contact any of the speakers with any questions that you might have about the things that we've covered. We've really enjoyed presenting to you, and we wish you all the very best. And I'm going to go now and see how much of my house is still standing, having left 4 children to their own devices for half an hour. Thanks very much.